Hi everyone, I'm David Fisher, and this is Presidential Perspectives, where we take a look at current events through the lens of American history as seen through the lives of the presidents of the United States. In this episode, we focus on invoking the Alien Enemies Act, which is what President Donald Trump did this past month as his authority to incarcerate and deport several hundred members of the Venezuelan gang, Tren de Aragua. Now, the law actually goes all the way back to 1798. It has only been invoked 3 times in American history, always during wars. Let's take a look at the history. We go back to 1798. John Adams is president of the United States. The Americans are involved in sort of the quasi-war with France. Many Americans pushing the president to seek an actual declaration of war. Adams isn't ready to do that, but Congress is looking to empower the executive during these perilous times with some more power, basically in case there were issues against the government or with foreign nationals. So they passed a couple of acts, the Alien Acts and the Sedition Act, giving the president more authority, again, over foreign nationals and those that spoke out against the government. The Sedition Act, for example, said that any false, scandalous, and malicious writing or writings against the government of the United States or either House of the Congress of the United States or the President of the United States with intent to defame or bring them into contempt or disrepute or to excite against them or either or any of them the hatred of the good people of the United States, that was a crime. And the concern was about French nationals and their supporters in the United States. The Sedition Act by the Adams administration was invoked a dozen times, convicting and putting newspaper editors, pamphleteers, and even a sitting congressman in prison over that sedition law. The Alien Acts, and this is separate. There were 2 alien laws. The first was an act concerning aliens, which is also known as the Alien Friends Act. Now, in this act was completely monarchical, absolute authority to the President of the United States to detain and deport any foreign national that he determined to be dangerous to the peace and safety of the United States. There was no judicial review, no due process, the authority to detain and deport entirely in the hands of the President. An act respecting alien enemies is the second act, also now known as the Alien Enemies Act, what's in play here in the 21st century. This was more specific. It was intended to be used in times of war. Specifically, the Alien Enemies Act had these conditions: that whenever there should be a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion shall be perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President of the United States shall make public proclamation of the event. Those are the conditions in which you could invoke the Alien Enemies Act. Now, in 1798, John Adams did not invoke this act. In fact, he didn't invoke either of the Alien Acts. They were not used at all. As we mentioned, the Sedition Act was. This was controversial at this time. There were a lot of people opposed to these laws, specifically for either constitutionality issues or frankly even in the spirit of the new Republic of the United States. But the question is, what could they do about it? Judicial review was not yet in place in the United States. The landmark case of Marbury versus Madison actually hadn't happened yet. That was the case where the Supreme Court gave to itself the authority to rule on the constitutionality of federal laws, but that hadn't occurred yet. So what was the opposition to do? Well, the leader of the opposition happened to be the sitting Vice President of the United States and the founding father, Thomas Jefferson. And Jefferson worked with his friend James Madison. They were both so distraught over this, they sought to nullify these laws through the states, and they created what were called the Kentucky Resolution and the Virginia Resolution. Jefferson wrote the Kentucky Resolution, which said, whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That this government, created by this compact, was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers. But that, as in all other cases of compact among powers having no common judge, each party has an equal right to judge for itself, as well as of infractions, as of the mode and measure of redress. So what happened as a result of these nullification proclamations coming out of Kentucky and Virginia? Well, not much. No other state signed on, and then we had a presidential election. John Adams is out, Thomas Jefferson is in as the president. One of the first things he did was simply let the Alien Friends Act and the Sedition Act expire. But the Alien Enemies Act did not have an expiration date in it, and maybe the founders thought that since this could only be invoked during times of war, that it was more reasonable and they could allow it to stand, and it is still on the books today. As we mentioned, it's only been invoked 3 times, always during war. The first time was during the War of 1812. Madison is President of the United States, and to his credit, again, the sedition law was gone, but he didn't seek a new one, even though some people thought he should, because look, he wrote the First Amendment, and he wasn't going to infringe on that right of the Americans. But the Alien Enemies Act is on the books, and he did invoke it. Now, it was pretty limited invocation as far as we can tell. All he was required was some British foreign nationals to register with the federal government if they were resident in the United States. It does not appear that Madison actually deported any of those Brits based on the law, based on what I can tell, but there was an invocation of the act, at least for this registration purpose. We jump forward another 100 years before it comes into play again. Woodrow Wilson is the President of the United States. Now, interestingly, earlier in Wilson's career, as an academic, he actually took some shots at these acts, specifically here on the sedition law, which Wilson had said cut perilously near the root of freedom of speech and of the press. There was no telling where such exercises of power would stop. Their only limitations and safeguards lay in the temper and good sense of the President and Attorney General. Well, years later, he was the President, and he sang a bit of a different tune. During World War I, for example, he gave his full support to the Espionage Act of 1917. According to Wilson, I honestly think it would be impossible for me to conduct the war with success if I am to be placed under daily espionage. How your beliefs can change when you're in a different seat. Wilson also invoked the Alien Enemies Act, and he detained foreign nationals from the Central Powers during the war. In fact, some of those foreign nationals were held even after the war was over. Our third time, Franklin Roosevelt's president, World War II, invoking the Alien Enemies Act against German, Italian, and Japanese nationals, imprisoning about 30,000 of them, according to this particular statute. Now, that's separate from Roosevelt's Executive Order 9066, which was to detain in camps more than 100,000 people of Japanese descent, including American citizens. So you've got both of these in play. Decades later, the federal government issued a formal apology and paid out reparations to people who were involved on the Japanese detention under these actions. Now, all 3 of these were invoked during time of war. Today, there's more discussion about this broader interpretation of the other phrase, the invasion or predatory incursion by any foreign nation or government. Is that in play now? Seems like that is something that is going to be determined by the courts. Now, some people claim that the courts have no place in this, and it's entirely up to the executive, but that is not what the law said. The entire Section 2, highlighted here, the entire Section 2 of the Alien Enemies Act focused entirely on the role of the courts, including the following. It shall be the duty of the several courts of the United States to cause such alien or aliens to be duly apprehended and convened before such court, judge, or justice. And after a full examination and hearing on such complaint, and sufficient cause therefore appearing, shall and may order such alien or aliens to be removed out of the territory of the United States, or to give sureties of their good behavior, or to be otherwise restrained. So different options were available to the court. By the way, sureties to agree was basically to agree to that they would behave, that they would follow the law, and the courts could assess that in determining the final outcome of these cases. So clearly, based on the statute, the courts do have a role based on the text, and I put a link to the full text of this statute in the description below. That gives you an overall history of the Alien Enemies Act. For more on any of these stories, you can check out some more of the links that are in the description, some links to some other videos from Presidential Chronicles. You can also check out my books on Amazon.com. Don't forget to subscribe to this YouTube channel. I'm David Fisher. We'll see you next time. This is Presidential Perspectives from Presidential Chronicles.